Since the original production of Shadows to Light, there have been some changes to the Child Abuse and Neglect Reporting Act, which may affect you or others you know. The original act included the terms child care custodians and health care providers. Both of these categories have been deleted and replaced with the designation mandated reporters. Unless otherwise noted, volunteers are not mandated reporters, but are encouraged to report child abuse and neglect. Employers are now required to have their employees sign a statement outlining the reporting duties and responsibilities. Employers are also required to inform the mandated reporter of their rights to confidentiality regarding the disclosure of their name as the person making a report. Employers are now strongly encouraged to provide training to their employees who are mandated reporters and to all volunteers working under their supervision. In our original video, clergy members were not identified as mandated reporters. In 1996, however, clergy members were added to the list of mandated reporters and are currently included in the Child Abuse and Neglect Reporting Act. A clergy member is defined as a priest, minister, rabbi, religious practitioner, or similar functionary of a church, temple, or recognized denomination or organization. 2003 added 4 additional mandated reporter categories. Category 1 is any employee of a police department, county sheriff's department, county probation department, or county welfare department. Category 2 is any employee or volunteer of a court-appointed special advocate program. Category 3 is any custodial officer. And Category 4 is any person providing services to a minor under the Welfare and Institutions Code. Our original video described child abuse reporting as an individual responsibility. However, when 2 or more persons who are required to report jointly have knowledge of a known or suspected instance of child abuse or neglect, and when there is agreement among them, a single person from the group may make the report. If any member of the group knows that the report has not been made, they shall be required to make the report. 2006 added additional liability regarding reporting of child abuse. If a willful failure to report the abuse results in death or great bodily injury, the mandated reporter could face as much as a year in jail, a $5,000 fine, or both. Current law provides an additional protection for the mandated reporter by stating that any supervisor or administrator who impedes or inhibits a report of child abuse and neglect is guilty of a misdemeanor and could face both a fine and imprisonment. If death or great bodily injury happens to the child as a result of the abuse, the supervisor or administrator who impeded or inhibited the report is guilty of a misdemeanor and could also face a year in jail, a $5,000 fine, or both. In addition to sending in a written report, a mandated reporter may also fax or electronically transmit a written follow-up report within 36 hours of receiving the information concerning the incident. Of special note, immunity not only applies to a report made within the scope of a mandated reporter's employment, but it now also applies when a report is made outside the mandated reporter's professional capacity.